My name is Stephen Irwin, Treasurer for 2020 of Gray's Inn. This is the first of three events to mark the 75th anniversary of the opening of the Nuremberg Trial on the 20th of November 1945. As I hope most of you will know, the second event is the Birkenhead Lecture, which takes place next Monday, the 16th of November. The lecturer on that occasion is Sir Christopher Greenwood, who is a most distinguished international lawyer, formerly a judge of the International Court of Justice, and now Master of Magdalen College, Cambridge. He will focus on the trial itself and on some of the parallel proceedings. In the third event, a panel of distinguished experts will examine the legacy of Nuremberg and the successor jurisdictions. The panel will be chaired by Master Sir Howard Morrison, who is President of the Appeals Division of the International Criminal Court. The panel members will be Shehzad Kerania, Director General of the Attorney General's Office, Master Bill Clegg, who formerly acted as Defence Counsel before the International Criminal Tribunal for the former Yugoslavia, Professor Charles Garraway, who, following after a career as a senior army lawyer, represented the Red Cross and then became Stockton Professor at the United States Naval College. And he is visiting professor at King's College London and the general editor of the UK manual on the law of armed conflict. And the fifth panelist will be William Shawcross, CVO, historian, a member of Gray's Inn, son of Hartley Shawcross, and currently writing on contemporary anti-Semitism in Europe. In common with the other events, a recorded version of this will be available. A short bibliography is attached to your Zoom invitation, which should be useful for any who want further reading. One housekeeping point, if we hope that there will be time for questions at the end of this session. If you do have questions, please can you submit them using the Q&A box, which should be available to you all, rather than the chat function, because it will be easier to analyze them and bring them forward. Why bring ourselves to contemplate, once again, the appalling events which led to the Nuremberg trials? There's a natural tendency to put such things from our minds, to avert our eyes, to persuade ourselves that such things cannot recur, at least in our world, at least in Europe or in the West. But that averting of the eyes, that entirely understandable, partly subconscious turning away, carries a risk. If we lose focus, if we drift from acknowledgement of what has happened in the past and forego attention to it, we dissipate the energy needed to maintain measures which may diminish the recurrence of such events in the future. Atrocity confronts us with the necessity for effective international law and reminds us of the pressing case for a rule-based world order. As Professor Mary Fulbrook put it in a book you will find on the bibliography called Reckonings, which looks in wonderful and eloquent detail at the consequences of what happened in Germany and Eastern Europe. She said this: if we do not force ourselves to listen to these agonized accounts and to confront from this very safe distance the unthinkable images they convey, we cannot even begin to comprehend later attempts to live with this past. And for many members of later generations, particularly those with close emotional ties to perpetrator communities, it can become all too easy to listen to self-exonerating tales and give people the benefit of the doubt. Any reckoning with the past that cannot confront images such as these will remain only partial, inadequate to the enormity of the task of understanding Nazi persecution and its aftermath. The critical defense advanced at the first and best known Nuremberg trial, and at the trials which followed, was that the defendants were acting in pursuance of orders from their superiors, who were the legitimate rulers of Germany. And thus the defendants said that they were acting in accordance with German law. This touches on a profound philosophical and legal debate. Is the source of law the sovereign or the sovereign nation, or does there exist a higher law, often described as natural law, which in certain circumstances supervenes the law of the sovereign or of the state? As we shall see, this is an ancient debate, at least in its essentials. Here I will try and take the long view. It will necessarily be sketchy, so I hope you will forgive the need to travel quickly over time. Then I shall touch briefly on why there was a trial rather than summary action against the leading Nazi defendants. And thirdly, I want to give a brief picture of the distinguished members of this inn who played such a prominent part in the trial process. Atrocity is at least as old as organized warfare, and its roots lie in the dehumanization of the victims. I choose one example from British history. Considering the mindset of Roman imperialism in the context of the Claudian invasion of Britain, Professor Peter Solway in the Oxford History of England, Rome and Britain, writes this: "There was no third condition. If you were a non-Roman people, you were either dependent, subiecti, or proud and recalcitrant, superbi. The Romans felt they had an absolute moral right on their side. This overrode any possible obligations to other peoples. It is this doctrine that explains why, for example, the Romans felt they could treat minor kingdoms in their power, client kingdoms, exactly as they wished, or why it was entirely permissible to exterminate whole tribes who proved intractable. In the course of the revolt in AD 61 by the British tribe the Iceni, following the Claudian invasion and the breakdown of relations with the Roman authorities, the armies of Queen Boudica killed colonists and their families. There is a statue of Queen Boudica on the embankment in London. The Roman historian Tacitus wrote as follows: "A like destruction befell the town of Verulamium, modern St. Albans. For as the barbarians revelled in plunder and were disinclined to effort, they passed by forts and military stations and fell upon places rich in spoil, which had no garrisons to defend them. No less than 70,000 citizens and allies were slain. For the barbarians would have no capturing, no selling, no any kind of traffic usual in war. They would have nothing but killing, whether by sword, cross, gibbet, or fire, as though hurrying to avenge themselves beforehand for the retribution which was to follow." Modern historians doubt the number of victims suggested by Tacitus, but not the substance of this account. And the retribution did follow. At the decisive battle which took place on Watling Street, somewhere between St Albans and Wroxeter, the Roman frontier town on the Severn, as Tacitus again wrote, the legion dashed forward in a wedge-like formation. The auxiliaries charged no less vigorously, while the cavalry with spears couched broke through all serious resistance in their way. The rest of the host fled as best they could, the outlets being blocked by the ring of wagons behind. Our men gave no quarter, even to the women. The very beasts of burden, riddled through with darts, added to the heaps of dead. It was a glorious victory, fit to rank with those of the olden days. Numberless other examples, of course, could be given. Well, what had law to say to this problem? One might be forgiven for thinking that law had nothing to say to the problem of atrocity committed by those acting under orders of the state until modern times. But the notion of a natural law supervening local laws or the whim of the ruler was formulated long before Tacitus. The Roman jurist and politician Cicero wrote this: "The most foolish notion of all is the belief that everything is just, which is found in the customs or laws of nations. Would that be true even if those laws had been enacted by tyrants? Or if a law proposed that a dictator might put to death with impunity any citizen he wished, even without trial? For justice is one. It binds all human society and is based on one law, which is right reason applied to command and prohibition." Of course, Cicero lived under the Republic and was a strong opponent of dictatorship and of the contemporary Roman tendency towards autocracy. And in the end, he himself, of course, was murdered at the command of the dictator Julius Caesar and without a trial. In his masterly account of the development of legal thinking in Europe, Professor J.M. Kelly, the author of A Short History of Western Legal Theory, traces back to Cicero the development by early Christian thinkers of the doctrine of natural law, a notion which was widely articulated by the Church during the Middle Ages, notably by St. Thomas Aquinas in his Summa Theologiae. For Aquinas, natural law was the product of rational thinking about the condition of mankind, although the true higher law was the eternal law, God's law, from which he held all law was ultimately derived. There are signs, I would suggest, that people in many places and times have thought, or perhaps simply instinctively felt, that not all is fair in war. For example, both Saxon and Norse codes of justice, with pre-Christian origins, provided for compensation for injury and death, even where that arose in the kind of warfare prevalent in those societies. King Alfred's code provided for different levels of compensation for men and women, for the free and for slaves. Nevertheless, the implication was that obligations arose. A similar point might be made in relation to the chivalric codes arising in medieval Europe. In his play Henry V, Shakespeare describes an episode where some of the French army murder the boys who were looking after the baggage at Agincourt. Whether or not this episode actually took place is not perhaps central to the point. Shakespeare clearly knew his audience would respond to this as an outrage. He voiced the reaction in dialogue in the play between two experienced soldiers, the Welsh captain Llewellyn and the English captain Gower. And here it is, Llewellyn. Kill the boys and the luggage. 'Tis expressly against the law of arms. 'Tis as arrant a piece of knavery, mark you now, as can be offered. In your conscience now, is it not? Gower. 'Tis certain there's not a boy left alive. And the cowardly rascals that ran from the battle had done this slaughter. Besides, they have burned and carried away all that was in the king's tent, whereof the king most worthily hath caused every soldier to cut his prisoner's throat. Oh, 'tis a gallant king. One may note with some irony that when Laurence Olivier made his famous film of this play in 1944, part of the British war propaganda effort, he included the French atrocity, but omitted the killing of prisoners at the king's order. Of course, that passage in Shakespeare illustrates a fundamental problem with any code of justice governing conflict, with any so-called law of war, save perhaps at times and places where the church, usually through the papacy or other international institution, could exercise supervening power. There was no worldly authority higher than the prince, and thus no means of enforcement. Scholars suggest that Henry V was written in 1599. A decade later, in Bonham's case, 1610, Sir Edward Coke, Chief Justice, addressed the enforceability of higher or natural law in a national context by asserting that the English courts had an ancient jurisdiction arising from natural law to treat as void even acts of parliament which conflicted with natural justice. He ruled, quotes, "And it appears in our books that in many cases the common law will control acts of parliament. For when an act of parliament is against common right and reason, or repugnant, or impossible to be performed, the common law will control it and adjudge such act to be void." At the same time, Professor Kelly identifies the 17th century as producing what he called the first virtual denials of the existence of a higher order of natural law. Somewhat disturbing for us at Gray's Inn, he focuses first on our own Francis Bacon. And he wrote this, quotes, "As an advocate, Francis Bacon had invoked the law of nature, but generally he rejected medieval notions intertwined with theology. And in an uncompleted work, Nova Atlantis, he presented law as the product of simple considerations of human utility, not the reflection of or something which should ideally conform with some higher order." Kelly identifies this as the emergence of legal positivism, a position echoed by Hobbes in Leviathan. It may well be that once Europe, particularly Protestant Europe, had moved away from the authority of the papacy, and princes, and not just in England, were understood to be ordained by God as rulers and began to assume leadership of the church in their domains, it became more difficult to identify a basis for law constraining the authority of the monarch. That was the difficulty of Sir Edward Coke. That was at the root of the English Civil War, a conflict that Irish and Scottish historians more precisely referred to as the War of the Three Kingdoms. However, again at much the same period, the idea of natural law was elaborated into a system by the Dutch Protestant scholar Hugo de Groot, or Grotius. In his treatise, De Jure Belli et Pacis, on the law of war and peace, of 1625, Grotius was responding to the horrors of the Dutch revolt against Spanish rule in the Netherlands and of the 30 Years' War in Germany. His seminal proposition was that natural law would retain its validity even if God did not exist. Grotius used the analogy of mathematics. He said this: "Measureless as is the power of God, nevertheless it can be said there are certain things over which that power does not extend. Just as even God cannot cause that 2 times 2 should not make 4, so he cannot cause that which is intrinsically evil to be not evil." As Professor D'Entrèves put it in his book, Natural Law, this, quotes, appears as a turning point in the history of thought. It was the answer to the challenge of voluntarist ethics. It meant the assertion that command is not the essence of the law. Grotius has been recognized as a fundamental influence on the subsequent development of international law, although the role of other jurists and philosophers may have been understated. In the period after Grotius, as Professor Shaw emphasizes in his book International Law, positivist legal thinking became dominant. He said this: "Positivism developed as the modern nation-state system emerged after the Peace of Westphalia in 1648 from the religious wars. It coincided, too, with theories of sovereignty, such as those propounded by Baudin and Hobbes, which underlined the supreme power of the sovereign and led to notions of the sovereignty of states. And yet, in a different strain of thinking which grew up during the 18th century, the theory of natural law developed into the concept of natural rights, the belief system or propositions which underpinned the American and French revolutions. Perhaps the most well-known text is The Rights of Man of Thomas Paine, published in 1791. This, however, was a vigorous debate at that time. John Locke proposed a system of natural rights. Edmund Burke, and perhaps more surprisingly, Jeremy Bentham, dismissed those ideas as nonsense. Through the 19th century, the thinking of the German philosopher Hegel was of huge importance. In relation to the formation of law, Hegel emphasized the role of the state in an analysis which is antithetical to the existence of natural law. As Professor Shaw puts it, since law was ultimately dependent upon the will of the sovereign in national systems, it seemed to follow that international law depended upon the will of the sovereign states. This implied a confusion of the supreme legislator within a state with the state itself, and thus positivism had to accept the metaphysical identity of the state. The state had a life and will of its own, and so was able to dominate international law. This stress on the abstract nature of the state did not appear in all positivist theories, and it was a late development. It was Hegel, says Professor Shaw, who first analyzed and proposed the doctrine of the will of the state. The individual was subordinate to the state because the latter enshrined the wills of the citizens and had evolved into a higher will, and on the external scene, the state was sovereign and supreme. Such philosophies led, he says, to the disturbing results we saw in the 20th century and provoked a reawakening of the law of nature, dormant throughout the 19th century. This brings us much closer to the Nuremberg Trial and to the events which lay behind it. I have already suggested how war and the horrors associated with it have been known from antiquity. The history of the 19th century is, of course, hugely complex, but I suggest that two areas of development in technology brought these issues into the minds of a widening public in the powerful nations of the world. The first development was the combined effect on warfare of the modern rifle and artillery, the explosive naval shell, of railways and the telegraph, the instruments of a major industrial power at war. The second development was photography. These factors came to prominence together, first in the Crimean War of 1853 to 1856. The doyen of modern war correspondence, William Russell of the London Times, was present in the field, and here is his photograph. His vivid writing and his criticism of military organization were augmented by shocking photographs of the effects of war. And we have one example for you tonight of the aftermath of the siege of Sebastopol. Perhaps even more striking was the impact of the American Civil War of 1861 to 1865. In the Battle of Antietam-Sharpsburg on the 17th of September 1862, there were more than 28,000 casualties, including 5,000 men killed outright on the field. Pictures of the field, particularly that of the Bloody Lane, shocked the world. It is suggested that the most likely number of soldier deaths in that war was 761,000. That does not include civilian deaths, particularly those of slaves or ex-slaves, and the total overall is likely to exceed 1 million. To get an idea of the scale of that suffering, the population of the USA in the 1860 census, the year before the war began, was 31,443,000, including 3,953,000 slaves. Similar scenes following the Battle of Solferino between the forces of France and Piedmont on one side and Austria on the other in June 1859 inspired the Swiss businessman Rt Hon to begin the process which led to the foundation of the Red Cross in 1863 and the adoption of the first Geneva Convention in 1864. In the late 19th century, as Ottoman power declined and the Ottoman Empire began to fragment under the pressure of local nationalisms, often stimulated by the great powers acting as patrons for client groups. These groups, defined on ethnic and often religious grounds, represented potential client states for the great powers, competing for the spoils. As we saw again at the end of the 20th century, such conflicts in the Balkans were accompanied by terrible atrocity. Those events resonated in the public sphere in London, Paris, Vienna, and St. Petersburg. As part of this turmoil, Austria-Hungary occupied Bosnia-Herzegovina in the 1870s and formally annexed the territory in 1908. 6 years later, in Sarajevo, in the summer of 1914, a Bosnian Serb group assassinated Archduke Franz Ferdinand, the heir to the Austrian throne, and that was the spark which lit the fuse for the First World War. The commencement of hostilities by Germany in 1914 represented a flagrant breach of international law. Not only was it a breach of treaty obligations, but the German army invaded Belgium, a neutral country. As the war proceeded, allegations of what were called Hunnish atrocities mounted. These were probably exaggerated, but there was certainly substance to some of them. The German sinking of the passenger liner Lusitania on the 7th of May 1915, with the loss of 1,100 passengers and crew, was a turning point for public opinion in Britain and in the USA. In fact, there were many other sinkings of passenger ships during the war. On the 31st of January 1917, Germany announced that it would resume unrestricted warfare in the war zone waters of the Atlantic. 3 days later, the USA broke diplomatic relations with Germany and entered the war on the side of the Allies. Within hours, the American passenger ship Housatonic was sunk by a German U-boat. All of those grievances led to demands for justice or punishment, both during and after the First World War. One of my predecessors as treasurer of Gray's Inn, F.E. Smith, later Lord Birkenhead, took office as treasurer at the turn of 1916 into 1917. He had been in office as Attorney General since October 1915. The Christmas holiday of 1916 saw him on a ship bound for New York and a speaking tour of America designed to garner support for the Allies in the war. 2 days before he left, he entertained the Prime Minister, Lloyd George, to dinner in Hall at Gray's. His biographer, John Campbell, suggests that this was the culmination of a determined campaign to be awarded the baronetcy, which now came his way. In the course of his speaking tour, F.E. Smith was consistently dismissive of President Wilson's plans, already then articulated, for the formation of a League of Nations after the war. While most of his speeches in America were more general, he delivered a major speech to the New York Bar Association on the 11th of January, entitled Law, War, and the Future, in which he considered the history and role of international law, the track record of Germany in breaking international law, and the prospect of punishment for those responsible for the breaches. He began by emphasizing that the coercive quality of law was critical. He said, quote, "In our domestic law, the power of punishing the man who is in breach of the law is essential to its very conception," end quote. And he went on to contrast this with the situation in international law. He said, "The difficulty in dealing with international law has always been that there has been no sanction in our public law. And sanction, as you very well know, is the term technically used to express the penalty which is imposed on the wrongdoer." Of some interest today is a passage from the speech in which Lord Birkenhead recounted that he, as Attorney General, had argued before the Judicial Committee of the Privy Council that orders in council, that is to say, the executive orders of government, as opposed to legislation by Parliament, which sought to set aside some provisions of international law, could not be challenged or called into question in a British prize court. Although he had argued in that fashion, in his speech, Birkenhead went on to cite the judgment of Lord Stowell, the great judge in the English prize or admiralty court at the time of the Napoleonic War, in which Lord Stowell rejected essentially the same argument in the following terms. "We sit here as a court of international law, and in spite of what our enemies have done, we still believe that there are binding doctrines of international law. And sitting here as we do as a court, whose duty it is to construe those doctrines, we utterly refuse to be bound by orders in council issued by the executive. And if you force us by Act of Parliament, as you can, to recognise your orders in council, we will recognise them because we must. But it will become clear to the world that we have ceased to be a court which administers international law, and that we have become the mere mouthpiece of executive and legislative authority in this country. Against that backdrop, Birkenhead went on to castigate German breaches of treaty obligations and international law. He contrasted the attitude of Germany to the position as he held it to be, both in England and in the United States. He said this: "It would have been as absolutely impossible for a great statesman in your country to go before his fellow countrymen as it would have been for a great statesman in my country and say, we made that treaty, but the conditions have altered. It does not pay us to observe it. We propose to break it." Such a minister, said Smith, would have been broken in England. Such a minister would have been broken in your country. Lord Birkenhead's conclusions were, in essence, that without the agreement of sovereign states to comply with international law, it would only retain the quality of law ultimately by enforcement through war. He said, if we win, and if we punish those who have broken the public laws of the world, international law will have received a supreme public vindication. Perhaps no nation, however strong, will ever dare again dream of aggressive war. Perhaps, I do not know, perhaps the great and splendid dream of an international tribunal administering a law which would satisfy the analysis I have already examined may be realized. Perhaps, I say, these things may happen. But he went on, will a Prussian, crouching for a second spring, be an agreeable bedfellow, by which he meant in a League of Nations? Is an unpurged Germany a possible member? Obviously no, only a punished Germany. So by every route, we are driven back to the one static feature in a dynamic controversy. Public law disappears forever from this world if we are proved powerless to castigate the wrongdoer. Yet I agree that it is worthwhile trying for the ideal. It is worthwhile to make the attempt. It is better to harness your wagon to a star than to a machine gun, though a knowledge of the one may be very useful as a means of attaining to the other. At the Versailles Peace Conference after the First World War, a multinational committee of lawyers was set up to draw up charges against German leaders accused of war crimes. This committee considered adding a charge of causing the war itself, but they could not agree if that was a crime in international law. The lawyers abandoned the idea, but the politicians grasped it against the legal advice they were given. German war guilt was written into the Versailles Treaty, and in Article 227, the Kaiser was accused of, quotes, a supreme offence against international morality and the sanctity of treaties, end quote. After much negotiation, it was concluded that a special tribunal with judges from Britain, the USA, France, Italy, and Japan should be set up to try the Kaiser. Article 228 of the treaty called for a series of military tribunals to deal with German leaders accused of violating the laws and customs of war. These arrangements broke down. A particular difficulty was that the Kaiser fled to Holland, and the Dutch government declined to extradite him. He remained in Holland until his death in 1941. In 1920, the Allies presented the German government with a list of over 900 individuals whom they sought for trial. The German government refused point blank to hand them over. It was said that if the demand was pressed, it would lead to a renewal of war. As a compromise, the Allies persuaded the German government to institute trials in Germany of those on the blacklist, with international observers. Those proceedings opened in Leipzig at the end of 1922. They were a farce. Many of the accused and witnesses could not be found, and there was no power given to the courts to force them to appear. 888 of the accused were acquitted, or their cases summarily dismissed. In respect of the few convicted, extremely mild sentences were passed. When several of those who had been sentenced escaped from prison, the warders received widespread public congratulation. These events formed a poor precedent for the formation of an international tribunal after the Second World War. I now move straight to the years of that Second War, passing over the decades in which the League of Nations proved ineffectual, the Nazis rose to power in Germany, the Allies underestimated or chose to ignore the threat from the revival of military power in Germany, and then war broke out once more. From the early years of the Second War, some within the Allied governments began to contemplate the aftermath of victory and how the aggressors should be punished. There was a complex churn of views within the Allied governments. For a period, Russia spoke in favor of trials of the German leadership. After all, Stalin had extensive experience of mounting trials, which only ever had one outcome. The issue became more acute from the time of the Normandy landings, when the Allies came to contemplate victory with confidence. Even then, in 1944, the French and British governments clearly favoured summary action against Hitler and the other German leaders. An enormous political battle was fought within the Washington administration, and President Roosevelt tilted from opposition to a trial process, his initial position, to a position of rather ambiguous support. By late in the war, de Gaulle favoured a trial. At the Yalta Conference in February 1945, Roosevelt set out to persuade the European leaders. The current British position was formulated in a Foreign Office paper, which stated that, quotes, the guilt of such individuals, and the example was given of Himmler, the guilt of such individuals is so black that they fall outside and go beyond the scope of any judicial process. Even after Yalta, the dispute as to how to proceed rumbled on. Lord Chancellor Simon, in discussion on the 12th of April 1945, led the British cabinet to the unanimous conclusion that, quotes, for the principal Nazi leaders, a full trial under judicial procedure was out of the question. The matter was not resolved until after the death of Roosevelt, which happened on that same day. His successor, Harry S. Truman, took an unequivocal view in favor of judicial proceedings. In their superb narrative history of the Nuremberg Trial, Anne and John Tusa wrote this, quotes, Truman had a profound belief in the beneficent power of law and the wisdom of judges, an abhorrence of summary execution, sensitive antennae to the balance of political forces in Washington, and greater drive and disposition to make decisions than his ailing predecessor. Truman wanted a trial, and he wanted agreement of its details quickly. Well, Truman prevailed. The convoluted detail of the negotiations to that point and the decisions as to procedure are set down in the Tues's masterly treatment of those events in chapters 4 and 5 of their book, which I would commend to anyone wishing to understand the important focus and development that led up to the trial itself. Following agonizing and extended debate between the lawyers of the victorious nations, the charges on the indictment were fourfold. 1, participation in a common plan or conspiracy for the accomplishment of a crime against peace. 2, planning, initiating, and waging wars of aggression and other crimes against peace. 3, participating in war crimes. And 4, crimes against humanity, that charge incorporating genocide. In due course, we will hear more, I am confident, of those 4 charges and how they were deployed in the trial from subsequent speakers. I turn now briefly to look at the 4 members of Gray's Inn who played such a prominent role in prosecuting the trial. They were Hartley Shawcross QC, David Maxwell Fife QC, Professor Hirsch Lauterpacht QC, and Major Elwyn Jones MP. In due course, all save Lauterpacht became treasurers of this inn. Hartley Shawcross was a glamorous figure, charming, lively, conspicuously good-looking, and a most effective advocate. He was a Labour MP who became Attorney General at the inception of the Attlee government in 1945. He was active in the preparation of the case, so far as was consistent with the huge responsibilities of the Attorney General at that turbulent time. He took the lead in the opening and closing addresses in the trial. Shawcross subsequently led a very successful career in the law and in business. He was one of the founders of the legal organization Justice. He lived to be 101 years of age, and in his 10th decade, he published lively and engaging memoirs, rather ruefully entitled Life Sentence. They are a delightful read. We will return to him this evening. David Maxwell Fife was a highly ambitious and driving lawyer and politician. He served as Solicitor General during the war in the national government, and then briefly as Attorney General in Churchill's interim government leading up to the 1945 election. Following that election, he took over the prosecution, including much of the preparation, and acted as the leader of the prosecutorial team whenever Shawcross was away, which was for most of the trial. He was a capable lawyer, an efficient administrator, and a phenomenal worker. Although cross-examination had not been thought to be a particular strength of his devastating questioning of Hermann Goering has often been thought one of the most noted cross-examinations in history. Maxwell Fife went on to be a champion of European integration, one of the instigators and drafters of the European Convention on Human Rights, became Home Secretary, and then became Lord Chancellor as Viscount Kilmuir. It was Shawcross who brought Hirsch Lauterpacht into the case. In the period before the trial, when the shape of the case and the charges to be indicted were under debate and negotiation, Shawcross gave Lauterpacht a seat on the British War Crimes Executive, I think it is fair to say that Herr Schlauterpacht possessed the best legal intellect, which was associated with the whole Nuremberg process. He was born in 1897 to a Jewish family in a small town in what was then part of the Austro-Hungarian Empire and is today part of the Ukraine. He studied law in the city that was then Lemberg, was subsequently Lvov, and is now Lviv. He moved to Vienna and then London, becoming an international lawyer. After a period at the LSE, writing several books on international law, he became an academic at Cambridge. He was crucial in the formulation of the indictment, and it was he who was principally responsible for introducing the count of crimes against humanity. He ended his career as a judge of the International Court of Justice. His story, including the story of his intellectual contribution to law, is told fully in that marvelous book by Professor Philippe Sands, East-West Street, again to be recommended. Not only was Herr Schlauterpacht a bencher of this inn, but so was his equally distinguished son, Professor Elie Lauterpacht. The Lauterpacht Center for International Law at Cambridge commemorates them both, and the inn is the grateful recipient of their magnificent library, the Lauterpacht's magnificent library of international law texts. Finally, a more junior lawyer at the time was Elwyn Jones. He came from Llanelli, fought during the war, and then served as junior counsel at the first trial after the war, the main Nuremberg trial, and leading counsel in one of the subsequent trials in Germany. A charming and engaging man, he was elected to Parliament in 1945 for Labour, and subsequently served as Attorney General, and then as Lord Chancellor under Harold Wilson and James Callaghan for 6 years during the 1970s. Gray's Inn is rightly proud of all four of these men and of what they did. Well, what did the trial all come to? I hope that question will be answered in the 2 succeeding webinars. I am not going to confront you tonight with any images of what the Nazi atrocities really meant. Many of you will already carry in your minds visual images that you've seen before. If there are those of you who have never seen such photographs or footage, then when you are ready, they are readily available online. As I've said, if we are to take on board fully why international law in this area is important, and perhaps even more so why enforcement of international law, so far as it can be established, must be achieved, then it is necessary to understand what these atrocities meant and what will arise somewhere, sooner or later, once again. I recommend to any of you who wish to look at matters very closely, Professor Fulbrook's book on the bibliography. What we are going to try and do, and we hope that it will technically work, to give you a short flavour of the trial, is to show you some of Hartley Shawcross's closing speech to the judges in the main trial. Not only is it a fine piece of advocacy, but it is a timely reminder of what they were dealing with. If this technically isn't good enough, we think it will be, but we have given you the link so that if the combination of what we do and your own equipment means it's difficult to watch, you will be able to yourselves to watch directly without the need for the complex system we're about to try. And when it is finished, I hope there will be time for some questions.
The purpose of the action is the liquidation of those Jews. Day by day, over years, women were holding their children in their arms and pointing to the sky while they waited to take their place in blood-soaked communal graves. 12 million men, women and children have died thus, murdered in cold blood. Millions upon millions more today mourn their fathers and their mothers, their husbands, their wives and their children. Rights as any man to mercy who has played a part, however indirectly, in such a crime. Let Graeber speak again of Dubno. The people who had got off the trucks, men, women and children of all ages, had to undress upon the orders of an SS man who carried a riding or dog whip. They had to put down their clothes in fixed places, sorted according to shoes, top clothing and underclothing. I saw a heap of shoes of about 800 to 1,000 pairs. Great piles of underlinen and clothing. Without screaming or weeping, these people undressed, stood around in family groups, kissed each other, said farewells, and waited for a sign from another SS man who stood near the pit, also with a whip in his hand. During the 15 minutes that I stood near, I heard no complaint or plea for mercy. I watched a family of about 8 persons, a man and a woman, both about 50, with their children of about 1, 8, and 10, and 2 grown-up daughters of about 20 or 24. An old woman with snow-white hair was holding the 1-year-old child in her arms and singing to it and tickling it. The child was cooing with delight. The couple were looking on with tears in their eyes. The father was holding the hand of a boy about 10 years old and speaking to him softly. The boy was fighting his tears. The father pointed to the sky, stroked his head, and seemed to explain something to the boy. At that moment, the SS man at the pit shouted something to his comrade. The latter counted off about 20 persons and instructed them to go behind the earth mound. Among them was the family, which I have mentioned. I well remember a girl, slim and with black hair, who, as she passed close to me, pointed to herself and said, 23. I walked around the mound and found myself confronted by a tremendous grave. People were closely wedged together and lying on top of each other so that only their heads were visible. Nearly all had blood running over their shoulders from their heads. Some of the people shot were still moving. Some were lifting their arms and turning their heads to show that they were still alive. I was surprised that I was not ordered away. You were asked to believe that these 21 ministers and leading officers of state did not know of these matters, were not responsible. It is for you to decide. Some, it may be, are more guilty than others. Some played a more direct and active part than others in these frightful crimes. But when these crimes are such as you have to deal with here, slavery, mass murder and world war, when the consequences of these crimes are the deaths of over 20 million of our fellow men, the devastation of a continent, the spread of untold tragedy and suffering throughout the world, what mitigation is it that some took less part than others, that some were principals and others mere accessories? What matters it if some forfeited their lives only 1,000 times when others deserve 1,000,000 deaths? In one way, the fate of these men means little. Their personal power for evil lies forever broken. They have convicted and discredited each other and finally destroyed the legend they created around the figure of their leader. But on their fate, great issues must still depend, for the ways of truth and righteousness between the nations of the world, the hope of future international cooperation in the administration of law and justice are in your hands. This trial must form a milestone in the history of civilization, not only bringing retribution to these guilty men, not only marking that right shall, in the end, triumph over evil, but also that the ordinary people of the world, and I make no distinction now between friend and foe, are now determined that the individual must transcend the state. The state and the law are made for man, that through them he may achieve a fuller life, a higher purpose, a greater dignity. States may be great and powerful. Ultimately, the rights of men, made as all men are made in the image of God, are fundamental. When the state, either because as here its leaders have lusted for power and place, or under some specious pretext that the end may justify the means, affronts these things, they may for a time become obscured and submerged, but they are imminent, and ultimately they will assert themselves more strongly still, their imminence more. Liberty, love, understanding comes to this court and cries, "These are our laws, let them prevail." And then shall those other words of Goethe be translated into fact, not only, as we must hope, of the German people, but of the whole community of men. Thus ought the German people to behave, giving and receiving from the world, their hearts open to every fruitful source of wonder, great through understanding and love, through mediation and the Spirit. Thus ought they to be. That is their destiny. You will remember when you come to give your decision the story of Dubno, but not in vengeance, in a determination that these things shall not occur again. The father, do you remember, pointed to the sky and seemed to say something to his boy. The room will adjourn.
Well, I hope you will think that a remarkable piece of history, that we still have such footage. While that film was played, I have been looking at some of the questions asked on the question and answer session, and I'm going to try and give you answers grouped as far as I can. I'm afraid I won't be able to deal with all of the points raised. I'm going to deal first with points raised by John Fitzgerald and Vladut Lebedatu to say this: the question of whether the Nuremberg trials formed a precedent and how far the effect of the trial of it taking place and being carried through, that is going to be the focus, both, I hope, of part of what Professor Greenwood will say, but also of the third session, where the panel members will look at the different jurisdictions that have been exercised since and at the contemporary scene. Then we have questions from the preacher Michael Doe and from Diederik from Holland. I'm going to take those two together. As the preacher has said, the doctrine of natural law being developed by the Christian church has arisen within the Judeo-Christian tradition. Once that tradition falls away, what is the basis of a doctrine of natural law supervening other laws? And Diederik's question was to the same effect, although rather more open-based. That is an enormous question, philosophically. Is the issue that there is law above and beyond that promulgated by a sovereign state must depend on some fundamental basis for any law which can be operated in that way, or which operates and arises in that way. It does not seem to me essential that a particular religious belief system underpins that. As I hinted earlier, an instinctive belief that matters cannot be right, even in the prosecution of conflict, arose in pre-Christian traditions. And it does seem to me that there can philosophically can be a proper basis for a natural law or an overriding law without necessarily there being a prevalent religious belief. But I recognize that is a question of the greatest difficulty and can't possibly be addressed properly in a short answer like this one. Then, in a question that in a way is connected with the one I've just addressed, a gentleman whose name is Kaluarachike, I hope I make a fair stab at the pronunciation, asks, is it a fair assumption that natural law supersedes sovereignty? It seems to me that it must. It must at least limit the power of sovereignty. If the sovereignty of a state cannot enfranchise, cannot make lawful atrocity, then it must be that natural law sets a limit to the capacity of a sovereign or a sovereign state to authorize action, to promulgate laws which conflict with fundamental values, such as not committing atrocities. It's a different question, as is already very clear from what I've said, as to whether it can be enforced. But logically, if a natural law exists and which supersedes the law of a particular state, then that must represent a limit on the sovereignty of that state. I can see no room for space between the two. There's then a question, and I don't have the name of a questioner, how did the Nuremberg trial distinguish, and what distinction should be made between those ordering a war crime and those carrying out those orders? The answer from Nuremberg and the implicit answer by the necessarily restricted number of people who could be tried in the main Nuremberg trial or in the 10 or 12 trials which followed, soldiers, doctors, jurists, etc., is that there was a distinction. Those who ordered such acts to take place had a higher culpability than those who merely took part. You will have seen the short clip from Hartley Shawcross that he said all those who were involved in crimes of this kind bear a very heavy burden of guilt. And that is probably right. But given the breadth of engagement of the 1930s and 1940s German society with Nazism, the breadth of the knowledge of what is happening that was held by contemporary German citizens, it would be quite impossible to have sought out and sought to try everyone who was implicated. It is that picture, or that is part of the picture, which is portrayed so eloquently in the book Reckonings, to which I made reference. Then I put together two questions, one anonymous and one from Avaya Williams. Was Nuremberg victors' justice? If one man's partisan or freedom fighter is another's terrorist, then must such international tribunals always be the justice perpetrated or carried out by victors over those who have lost? Well, that too is an enormously complicated question. On the narrowest level, it is clear that there was a genuine attempt by the judges in the main Nuremberg trial to distinguish between the roles of individuals. They gave markedly different sentences to different individuals, and they acquitted three. Three people were acquitted completely out of the first trial, and there were acquittals at subsequent trials. And so if the concern is that such trials will always be trials enforced, mounted and enforced by victors, the answer to that may be yes, save where they are mounted and enforced by international agreement. If the implication is that trials mounted and enforced by victors are always by definition unfair, then there is an argument that they are not necessarily unfair, and that certainly those mounted by international agreement and through the institutions that have grown up since 1945 to 1949 demonstrate that there can be fair outcomes for individual trials. Undoubtedly it is the case, as one of the panel members I know will make clear in due course, it is the case that the three largest military powers in the world now, largest in population and military power, America, Russia, and China, none of them have submitted their own citizens to the international jurisdictions. Whereas it doesn't really matter or didn't seem to matter what the government of Liberia said. The president of Liberia responsible for atrocity was tried before the International Court. So we go back, I think, on this question, and it's a fundamental one, to what Lord Birkenhead was saying in his speech in New York. Without the capacity to enforce international law, it will not be fully enforced. And it is the accession to international jurisdictions, the understanding by the developed nations and all nations, if that's possible, that such an international rule-based order is the only way in which there can be some inhibitory effect on atrocious activity or misconduct in war. It is only when that penny drops and proper support is given by the international community that justice can be other than victor's justice, and therefore haphazard, depending on who wins which conflict and how enforcement can be mounted. I think we've reached at the end of quite an intense hour and 20 minutes, and I'm very grateful to all of you for joining in this session. I do hope that you have found it informative, and I do hope that you will feel it is, that you will look forward to joining in the other two events, which will come over the next 2 or 3 weeks. This is an anniversary we should remember. These issues are of real significance. A good evening to you all.